Good morning to all of you. Honorable Justice F.M.IBRAHIM KALIFULLA, former Judge of the Supreme Court of India, Mr. Justice Kumaresh Babu, Judge of the High Court and from the chambers of Sri R.Krishnamoorthy, Sri G.Masilamani, Senior Counsel, to whom I owe a great debt of gratitude. In fact, he proposed my name as a Senior Counsel and Mr. N.R. Chandran seconded it. And I think Mr. Shanmugasundaram and myself were the last two seniors who were appointed by a full court. Thank you, sir. I always remember that. My dear friend, Professor Gauri Ramesh, Registrar of TNDALU, and my dear friend Sundar, who without my permission disclosed that it's my wedding anniversary. When this decision was taken to give the endowment lecture and my dear friend Prakash met me and asked me to deliver it, I didn't have a moment's hesitation to say yes, out of the enormous respect, regard I have for late R.Krishnamoorthy. While thinking of the topic, I chose this because this has been bothering me for a long time. The unforgotten, unknown and remarkable role of this Madras High Court. I came from Bombay in 1976 and joined the Madras Law College. The first year was the emergency. There were no strikes. Colleges went on time. And I think I learned more in the first year than I did in the remaining 2 years of my practice. From the second year, we started having this unfortunate problem of strikes. But the unintended benefit was that the moment college would be declared as a holiday, I would walk across to the High Court and observe the great people practicing there from 1976 onwards. And when I look down the corridors of time, I can still see V.K.T. Chari, I can see Mr. Keshav Iyengar, M.R. Narayan Swamy, V.P. Raman, Govind Swaminathan, all these people were there. And then the next generation, outstanding lawyers were taken over by Sri R.Krishnamoorthy, Sri G.Masilamani, and so on and so forth. Now to my young friends here, I must tell you that having traveled to several high courts in the country, without question, the Madras High Court is the most impressive and majestic court building in the nation. For those, I don't know how many of you have gone for NL Raja's Heritage Walk on Sunday, but even in the Law College, I learned that this is the second largest court complex in the world. The first is the Royal Courts of Justice at the Strand. If you go to London, just go off Chancery Lane, you will come to the Strand Courts, the Royal Courts of Justice, and the second is the Madras High Court. There are very, very many important features of the Madras High Court. I'll just mention one and I'll go on to the other point. This majestic building was built at a cost of rupees 12 lakhs, that's all. Today you can't get a Maruti car for 12 lakhs, but that was the cost of this entire building. And at that time, there were only 5 judges. If you see the building, I always take it this way. To use a computer analogy, if the building of the High Court is the hardware, then the lawyers and judges of that court become the software. And it is they put together, they take the court to great heights. And when I've been working on my books and I've had the opportunity of reading old judgments, I then realized the outstanding judges that we had, and I must say that they wrote outstanding judgments partly because they were addressed by very, very eminent lawyers as well. I was told, and Justice Kalifullaa may bear me out, that very often the quality of a judgment depends to a certain extent on the quality of the arguments that are made before it. So Madras High Court has got a magnificent building, and we have had a magnificent galaxy of lawyers and judges in the past, of whom I'll speak shortly. And this put together makes the great Madras High Court. I would request you not to underestimate the great legacy we have We should be proud to be in the Madras High Court. I come from Bombay, I've been to the Bombay High Court, I've been to Calcutta, I've been to other high courts, but believe me, this is a truly impressive, majestic building. Now coming to Sri R.Krishnamoorthy, much has been said about him, and in fact it is difficult to exaggerate what a great gentleman he was. When I was a lawyer, we used to get that Ho and Company diary. I don't know if it is still there. There used to be a long diary published by Ho and Co. And if you open that Ho and Co, we used to buy it every year. There was a piece on what makes a perfect gentleman by Cardinal Newman. You can still get it on the net, Cardinal Newman's description of a perfect gentleman. And without a trace of flattery, without any exaggeration, if you just keep that Cardinal Newman's description as a gentleman and think of R.K. sir, both will match. Now coming to this topic of March of Constitutional Law, I chose it after having a detailed discussion with Prakash. Justice KALIFULLA mentioned about this great document. I'll just spend a few minutes and then go on to the actual topic. In the recent past, there's been a great tendency to keep criticizing everything as part of the colonial legacy and something which has to be looked down upon or something which is simply borrowed. As Justice KALIFULLA pointed out, the Constituent Assembly started its meetings in 1946, and the Constitution Day, that is Law Day, which is now called the Samvidhan Divas, 26th November. On 26th November, the final draft of the Constitution was settled. And then the Assembly adjourned till 26th January 1950, when the Constitution actually came into force. The last speech of Dr. Ambedkar on 25th November 1949 summarizes the work that had gone, and Dr. Ambedkar mentioned that they worked for 3 years. More than 6,700 suggestions were received, 2,700 amendments were made, and this constitution has been made by the great effort of our founding fathers, and it is something to be cherished. Professor Tom Ginsburg of the University of Chicago, incidentally he is coming to Delhi to give a lecture at the Palkhiwala Foundation with the University of Chicago. He has made a comparative study of more than 195 constitutions across the world. And he found that the average life of a constitution is just 17 years. The longest constitution is the US Constitution, and the second longest is the Indian Constitution, which is now completed 75 plus years. And our journey is even more remarkable than the US journey because of the diverse situation in India, the kind of 28 states, so many languages, so many cultures, yet we still have pulled on. And I personally believe that as long as the basic structure doctrine continues, this constitution will continue to survive. And you don't have to do anything. Just see the concurring opinion of Justice Mudholkar in the Sajjan Singh case, where for the first time it was he, not Dieter Conrad, anybody, it was Mudholkar in the Sajjan Singh case of 1965. See, by 1965, Constitution came on 50th, 1950. By 1965, the Constitution was amended 17 times. So people started getting worried. Can you keep on amending the Constitution like this? Is it something permanent? The Supreme Court till then had held that Constitution can be amended. The powers of amendment are untrammeled. The Parliament can change whatever it likes. Nothing can be done about it. But in Sajjan Singh, though he upheld the validity, he flagged the danger. He said that, this is a very important thought for all of us. He says you can amend the Constitution, you can do what you like. But he said, suppose in the Constitution, you say you have unchecked power of amendment, you can do what you like. Suppose you remove right to life. If you remove right to liberty, right to practice your religion. If you remove these rights, will what is remaining, will it be worth a constitution at all? It will be a constitution only in paper. And this is the point I want to make. Mudhalkar points out that there are certain essential features of the constitution which you cannot change. And it is a strange irony that he gets the word essential features from a judgment of the Pakistan Supreme Court. Justice Cornelius, a Christian gentleman, was the Chief Justice of Pakistan. He used the word essential features, which Mudhalkar took up and said, there are certain essential features which you cannot touch. And then he asked the question, what are these essential features? And he said, just look at the preamble. They will give you the essential features: liberty, equality, fraternity, justice. As long as these are there, the country will remain a republic, democracy. Now, I chose this topic of March of Constitutional Law. I just highlighted that importance of the Constitution, and let us not take it for granted. It is something to be cherished. Mr. Palkhiwala said that the price you pay for liberty is eternal vigilance. We have the citizens constantly on the guard that our rights are not slowly taken away. Now, coming to the March of Constitutional Law and the role of the High Court. What is happening now, I found, is that now today, if you take the Supreme Court cases, there are 20 volumes per year. We have 34 judges in the Supreme Court. The unfortunate consequence which I find is that very many outstanding judgments of the High Courts get unnoticed in this tsunami of the Supreme Court judgments that get all over. And when I was working on the book, one thing I followed, I learned it from my seniors, and I would recommend my young friends to also do, is that when you go to the Supreme Court judgment, and if it has come from a particular High Court, it is worth seeing what that High Court said about it. See what the judgment of the High Court was. And I started the practice of trying to do that, and in the course of that I realized that there were priceless gems of judicial wisdom which our High Court gave, which went to the Supreme Court. People only remember the Supreme Court, they have forgotten what the High Court has said. And that's why I said the topic was the unknown and the remarkable role of the Madras High Court. And I'll just give 5 cases and one thing about the 9th schedule, and I'll complete my lecture. Now, as Justice KALIFULLA pointed out, our constitution came on 26 January 1950. For the first time, Part 3 gave us fundamental rights, right to property, right to free speech, and so on. Now, very many constitutional problems triggered from the then Madras Presidency. One case is not from the Madras High Court, but all of us have heard the A.K. Gopalan case, right? In fact, incidentally, I have been trying, Justice KALIFULLA will know, that A.K. Gopalan is writ petition number 13 of 1950. I'm still trying to find out which was writ petition number 1 of 1950, which was writ petition number 2. I'm not able to get the answer. Anyway, A.K. Gopalan was arrested in Madras. He was in Madras jail, and his writ petition was filed in the Supreme Court. The 13th writ petition filed in the Supreme Court was the A.K. Gopalan case. It was argued by Sri M.K. Nambiar, one of the greatest constitutional lawyers and the father of Sri K.K. Venugopal. But I'm not dealing with A.K. Gopalan because my role is to stick to Madras High Court judgment. But I'm saying that the first landmark judgment on Article 21 was triggered by an arrest from Madras, argued by a gentleman, by Sri M.K. Nambiar. That's ultimately led to A.K. Gopalan. As far as the Madras High Court is concerned, the first important case was of Mr. V.G. Rao. All of you have heard the name Rao and Reddy, a famous firm which dealt mainly in labor matters. And V.G. Rao was a barrister and the General Secretary of People's Education Society. It had, from the judgment, it had leftist leanings. And immediately after independence, a lot of communists were arrested, detained, and so on and so forth. Now, V.G. Rao's matter was challenged before a full bench of the Madras High Court. And if you see the earlier judgments, you'll be amazed at the boldness with which they struck down the legislation when they found an infringement of liberty. The danger in V.G. Rao was the government issued a notification saying that People Education is an unlawful association. The law said they can notify an association to be unlawful, and by just notifying that, even the members would suffer imprisonment. So if they declare the Bar Association to be unlawful, all the advocates or members also can be liable to prosecution and imprisonment. That was the draconian law. Now read, if you get the time, it is AIR 1951 Madras 147. Those who are interested, please read the judgment. 1951 Madras 147, full bench. And particularly read the judgment of Vishwanath Shastri. Arguments are made. The petitioner lawyer, M.K. Nambiar, says that my freedom is untrammeled and the court can do anything to strike it down. Shri V.K.T. Chari, the Advocate General, he says no. The executive is there. You can't, when the executive says it's unlawful association, when they are going to protect public law and order, you can't interfere. Now, for the first time, a very important passage is made by the Madras High Court. Lot of cases are cited from US Supreme Court, Australia, and so on. And what Justice Rajamannar says, Chief Justice says, in the US, the Supreme Court can do what it wants. In the UK, Parliament can do what it wants. But in India, neither Parliament nor the Supreme Court can do what it wants. All are bound by the Constitution. We are all creatures of the Constitution and we must be a part of the Constitution itself. And on that basis, they struck down this notification as violating the right to form associations. Very superb kind of language has been used. In one case, many American judgments are cited. Vishwanath Shastri, Justice Shastri makes a very telling sarcastic remark by saying, we are now governed by 19(1)(c). And he says, so many foreign judgments have been cited, but I will refer to only a parsimonious few of an embarrassing wealth of American citations. So he said that too many citations are there, I'll ignore all of them and go by our Constitution. V.G. Rao goes to Supreme Court and Chief Justice Patanjali Shastri affirms the judgment of V.G. Rao. So the first important contribution of our High Court is the importance of liberty, importance of forming association, and what it says is, you can't have association by you can't have guilt by association. Just because you're a member of an association and that association is found to be unlawful, the members of the association cannot face adverse consequences. That's a very important thing. We are still fighting that in the UAPA. 45D says so. If you're a member of an unlawful association, the members also suffer this. That is under challenge in the Delhi High Court. We'll be arguing it in January. But what was said in that day, unfortunately, still continues today. That is a sad commentary. Now the next important case is Champakam Dorerajan, which all of you must have heard, the famous communal GO. Now, Article 15, which was first started, it said that the state can make special provision, but state cannot discriminate only on grounds of religion, race, caste, sex. Now this GO said they had a kind of a quota system which is very peculiar. For every 14 seats in medical or engineering colleges, 6 would go to non-Brahmin Hindus, 2 to backward Hindus, 2 to Brahmins, 2 to Harijans, 1 to Anglo-Indians and Christians, and 1 to Muslims. So 14 seats were divided in this particular form. The Madras High Court full bench struck it down saying that this is nothing but discrimination on grounds of caste. That went to the Supreme Court upheld it. And just to make my point, without meaning any disrespect to any court, read the Madras High Court judgment, read the reasoning in the Madras High Court judgment. Supreme Court affirms it, but you will find the quality of reasoning, the outstanding language of Justice Rajabannar, Justice Shastri, Justice Somasundaram is really remarkable. That's why I said these High Court judgments are our priceless treasures which we should not forget. I wanted to bring it to your notice. Now, danger starts. 1950, the Constitution comes. This judgment of declaring associations unlawful is struck down, affirmed by Supreme Court. So all over the country, wherever these communist organizations were declared unlawful, all of them were struck down. Zamindari abolition, people started acquiring land, but government did not pay compensation. land acquisition laws were struck down. Romesh Thapar, Crossroads, Article 19(1)A, freedom was struck down. So case after case after case was going against the government. There was panic. And if you get time, there's a fantastic book, wonderful book called 16 Stormy Days by a person called Tripur Daman Singh, who has given the background of the First Amendment. Now, when the government started losing case after case in Zamindari, freedom, association, reservation, all these cases were going, Pandit Jawaharlal Nehru said, the constitution is being hijacked by lawyers. He used the word purloined by lawyers. And we will not allow our Zamindari reform to be stonewalled or allowed to be stopped. But what to do? In fact, as a student of constitutional law, if the government had just paid reasonable compensation for all, half the problem in the country would not have been there. We would not go up to basic structure. But coming back to 1951, what is the solution now? Article 19 is there, 14 is there, 31 right to property is there. How do you get over this? Then comes the Madras genius. Sri V.K.T. Chari, who was the Advocate General, he wrote to Mr. P.M. Sundaram, who was the Law Secretary, why don't you do one thing? You have a 9th schedule. There are 8 schedules in the Constitution. Make a 9th schedule. Whatever law is put in the 9th schedule, you make it immune from attack. So once I can make any law, I can take away your land at 45 rupees and put it in the 9th schedule, nobody can question it. So this law, 9th schedule, was made, and this, as I said, is a unknown contribution, and it was discovered, nobody knew about this. Granville Austin, when he wrote the book Working of an Indian Constitution, he was going through all the constitutional papers in the Nehru library, and he found that this correspondence between V.K.T. Chari and P.M. Sundaram, saying you create this schedule and say that any law put in that schedule will not be liable to attack. Gajendra Gadkar remarked sarcastically, we are the only constitution where the constitution requires a protection against itself. So this is the comment made. So this is the 9th schedule which came. Now in the 9th schedule, once you place the law in the 9th schedule, nobody can attack it. So all the land reform laws were placed. Many other laws were placed there, and they got full protection. Just to fast forward, from 1951, this First Amendment was moved on 10th May 1951. And interestingly, to tell your students, there is still a debate whether the First Amendment is correct or not, because that time there was no Rajya Sabha. Article 368 says amendment by both houses. There was no second house. So whether that amendment was valid or not is still a question that is raised in Shankari Prasad but not fully answered. But that's an interesting conundrum of constitutional law. How could you strike down a law when there was no upper house? So after Champakam Dorarajan, after V.G. Rao, 1951, they made a law, 9th schedule, and over the years, almost 300 acts were placed in the 9th schedule, which were immune from attack. Fast forward to 1973, Kesavan Bharati. Kesavan Bharati was the Matadipati of a Math in Kerala. His lands were taken away by the Kerala Land Reforms Act. That was struck down by a full bench of the Kerala High Court. What did the government do? They took those same acts and put in the 9th schedule and retrospectively said all these laws are valid. So his lands were taken away and nothing could be done. He questioned that in the Supreme Court, and the Supreme Court finally said that you can amend the constitution but you can't take away the basic structure. Now the 9th schedule gives complete immunity only up to 24th April 1973. What the Supreme Court has said is after 1973, if you make any amendment, see, you can't put anything in the 9th schedule except by a constitutional amendment. So any law you put in the 9th schedule can still be challenged if it violates basic structure. So to that extent, the immunity is gone. And today, as I said, we completed 75 years. And as I told in some other lecture also, if we preserve the basic structure, we will easily complete 100 years, 125, 150. That is my personal view. Now, after that, What are the other two cases which I will deal with? One case which we don't realize the great importance is a simple sales tax case, which then defined the scope of state's legislative power. Now, those of you who are students here and all lawyers, you know this, in the list one there is entry 97, laws not otherwise specified, residuary entry. Just see how a simple case goes into a great constitutional principle. Rajaji, many of you don't know that the first sales tax law in the country was in Tamil Nadu. The Madras General Sales Tax Act 1939 was one of the first sales tax laws. To get more money, they were taxing sale of goods. Lot of building construction was going on. So he said all works contracts shall be deemed to be a sale and levy tax on that. He said works contracts shall be deemed to be a sale. Justice Satyanarayan Rao, an outstanding judge who went to Andhra after the state reorganization, he and Justice Rajgopal had given us judgment on sales tax where they discussed this constitutional principle, and this is worth listening to carefully and analyzing. He said that the states have a power to tax sale. What is sale? It's not defined in the Constitution. But he said, when Constitution uses the word sale, sale is nomen juris, it means something. Sale means there should be a seller, there should be a buyer, there should be transfer of property in goods. The goods of the seller should become the goods of the buyer. And he said in a works contract it doesn't happen. And this is the most important principle laid down, which is applicable to list 2 and list 3. He said, if a word is given as sale, then the legislature of a state cannot create a legal fiction and treat transactions which are not sales as sale and tax them. In other words, if you got the power to tax betting and gambling under entry 34, you can't deem something which is not betting and gambling and tax it. That's why in this gaming controversy which were involved, games of skill are never betting and gambling, and the Supreme Court said you can't expand your power and say even a game of skill becomes betting and gambling. So this is a very landmark judgment decided by the Madras High Court, and interestingly, it goes to the Supreme Court, and the Madras High Court judge, Venkatraman Iyer, he gives another landmark judgment saying, yes, state can only tax what is a sale, they can't go beyond their power. The fourth case, I'll just come to M. Karunanidhi's case. This is on repugnancy. The Tamil Nadu Act said that Public Persons Criminal Conduct Act, they filed a case against late Chief Minister on the ground that there were some corruption charges on procurement of wheat from Punjab. And he argued before 5 judges that the state law is repugnant, is contrary to IPC and CRPC and Prevention of Corruption Act. State has no power to get into these laws because central laws are there. State law is repugnant to the central law. 5 judges heard it and they negative the challenge. It goes to the Supreme Court, and the Madras High Court and the Supreme Court have laid down the principles of repugnancy which are valid till today. Now a small break on this. Why was it heard by 5 judges? Justice KALIFULLA mentioned that he joined the bar in August 1975. Sir, it's your golden anniversary of practice at the bar. Yes. I think you will be one of the few people in the audience who has seen the beginning of the emergency, lived through the emergency, and practiced in the High Court when the 42nd Amendment was in force. Now, why was Karunanidhi's case heard by 5 judges? Why not by 2 judges? Or why not by 3 judges? You'll be shocked to note that the 42nd Amendment, which Sirvai called an outrage on the Constitution, an obnoxious outrage of the Constitution, the 42nd Amendment said, and believe me, from 1975 till 1978, till the 44th Amendment, the law was a High Court could not question a central act. No High Court could entertain a challenge to a central act. Next, any challenge to the State Act also must be heard at least by 5 judges. And even in that 5 judges, there should be 2/3 majority to strike it down. So with all this restriction, it was heard by 5 judges. Fortunately, after the Janata Party came to power, they removed all those submissions. So that's how Karunanidhi's case came to be heard by 5 judges. Incidentally, those who are interested in statistics, the Madras High Court has given 13 judgments of 5 judges and about 56 or 57 judgments of 3 judges. And out of 13 judgments, 5 relate to constitutional law. So I was just doing a study on that, just to see what our contribution to constitutional law is. There's no time to get into other important judgments on that. And finally, I will now come to the Madras Bar Association. Recently, we succeeded before the Supreme Court in what is MBA 6. And I'll take this opportunity of thanking the wholehearted support of the Madras Bar Association, Mr. Gandhi, Sri Vijay Narayan, Kamal Nathan, and all the presidents they gave. Incidentally, the first case is R. Gandhi versus Union of India. So people in Supreme Court keep on saying R. Gandhi case, R. Gandhi case. How is it R. Gandhi? Interestingly, when we filed the writ petition, I put the title Madras Bar Association represented by President Sri R. Gandhi, by Thiru R. Gandhi. Surprisingly, the charter of the Madras Bar Association was not available. It was formed in 1865. So the section took an objection and the registration enga irukku, sir. I said, it's not available. I said, you know Madras Bar? No, sir. If you don't have registration, they can't file a writ petition. Then we had a via media with the Registrar Judicial. I put R. Gandhi, President Madras Bar Association, and then we filed the case. That's how it became R. Gandhi versus Madras Bar Association. Incidentally, L. Chandrakumar also is a member of our association, another leading case. Anyway, so this, in the emergency, in the emergency, the 42nd Amendment started tribunals. 323A, 323B, the government could create tribunals. Now, if you see those sections very carefully, they could create tribunals for anything, including criminal law. So tomorrow they can have a banking tribunal headed by a commissioner of police, one bank manager and one judicial officer. That can be a tribunal and they can send you to jail. This particular provision, 42nd Amendment, now this is one of the puzzles of history is after the Janata Party came to power, Shanti Bhushan had a discussion with the opposition and said that because when the Janata Party came to power, they did not have majority in Rajya Sabha. So they wanted to repeal the 42nd Amendment. They could not do so without the collaboration of the Congress Party. So the 45th Amendment bill was moved. On the first round, it was about to lapse because there's no majority. It actually lapsed. Then Congress said, we will allow all the amendments except 2. You can't remove the word secular, socialist, and you can't remove the words, and you can't remove the chapter on tribunals. I don't know what was so great about tribunals, and we are paying this price for the tribunalization of justice. Tribunal after tribunal was created. This amendment came in 1976, nothing happened. Suddenly in 2002, there was a decision to start the National Company Law Tribunal. All the jurisdiction of the High Courts was taken away. All company would be by Company Law Tribunal. Who's the member of a tribunal? Any officer having 25 years experience in administration, economics, finance, marketing, etc. So when I argued the case, I said, joke that except fisheries and animal husbandry, you could be a civil servant and become a member of the tribunal. To our credit, to our luck, the matter came before Justice Jaisima Babu and Justice Karpa Vinayagam. We argued the case for quite a few days. Sri V.T. Gopalan appeared on the other side. And Madras High Court said, place limits on tribunalization, which is continuing till today. So MBA 1 was the first check on tribunals. Then what happened? They had the National Tax Tribunal. I'll just take 5 more minutes and I'll conclude. Then came the National Tax Tribunal. That is even worse. All tax cases, income tax, sales tax, excise, will only go to tribunals. High courts will have no power over tribunals, direct appeal to Supreme Court. We challenged that also. Again, Madras Bar Association challenged it. And that fortunately was struck down in full, thanks to Justice Nariman. He laid down the principle under separation of powers, executive, judiciary and legislature. The decision, the last word on substantial question of law must remain with the judiciary, not with any tribunal. So that was struck down. Then we don't have time. Then we had MBA 1, MBA 2, 3, 4, 5 and 6. When MBA 5 came, Justice Nageshwar Rao expressed the hope. He said that this association has consistently canvassed the preservation of the judiciary, and I hope this will be the last case. But his hopes were belied. We had to have MBA 6, and I don't know if you're going to have MBA 7 or MBA 8, but I think that with the Madras Bar Association, we will continue to preserve and protect the judiciary. Friends, my time is up. I must once again thank the organizers. No, my time is 12:10. So, thanks. Yeah. Friends, no, there are so many other things, but I just thought I'll mention Madras Bar Association. It's been a great, in fact, one TV channel said Madras Bar Association is a tribunal warrior. So, and interestingly, I'll tell you, when we first succeeded in the Madras High Court, and I will also tell you one thing, Mr. Maslaman will recollect, just Jaisimha Babu was sitting in court 3. We finished the arguments around lunch. After lunch, he started dictating the judgment and continued for the next day full. Non-stop, he kept dictating the judgment because he was going to retire after 15 days or 20 days. And that's how we succeeded. And Justice Karpavinayam also was fully supportive, and that's how we won that particular case. Then Madras Bar, of course, National Tax Tribunal. See what was happening to the tribunals and how the Madras Bar Association gave protection. In the company law, I'll just mention 2 points. In the company law, we said that, look, you are taking company law by people who don't know company law. I did research with my colleagues and found that throughout the world, there is no company law tribunal in anywhere. And then I realized on studying that tribunals are never allowed where the litigants are two private people. A tribunal is there only where the state is a litigant, like income tax, sales tax, or PMLA, and the other side is a citizen. But if both the litigants are tribunal members, it should not go to a tribunal. That's how we also tried to censure patent trademark also, just as Basha is here. We said it should go to the court because it's a list between two individuals. That was the thing as far as the first tribunal was concerned. And I said, don't have these tribunals. National Tax Tribunal also, you can't do it. How did we succeed? The National Tax Tribunal came. It was an ordinance. It was going to come on 30th October. We moved a lunch motion. I appeared before Justice Subhash Reddy was there. He refused to give stay. To my luck, the next day, a notice was put up in the MHA, High Court Advocate Association, calling for applicants for National Tax Tribunal. One of the people were sitting or retired judges. And that advertisement in the notice board said all these people should apply with their passport size photograph, SSLC certificate, degree certificate. So I took with the help of him, I took a Xerox copy, again went to the Chief Court and said, look, this is what they're doing. They're expecting High Court judges to apply with passport photograph and schooling certificate. Immediately he gave a stay of the tribunal, and the tribunal never at all came into being. So this is how these are all strokes of history which saved the judiciary. Because I told the judges in the Supreme Court, company law is gone. Today, a High Court judge, if he gets elevated to Supreme Court, he would have never opened the Companies Act because courts are not due jurisdiction. If you go to tax, if you take away tax also, one of the arguments which we made before Justice Kher and Justice Nariman was, company law is gone, trademark is gone, DRT is gone, TDSAT is gone. So at the end of the day, High Courts will have only CPC, CRPC, article, nothing will be left with the High Court. And thanks to the Madras Bar Association, today taxation is still with the High Courts, and I hope and pray, we are trying our best to say that let NCLT do only IBC cases, that's taking all their time. Company law, operation mismanagement should come back to High Court judges, should come back to the company codes. So this is the struggle of the Madras Bar. We are still, and I hope we should succeed in the near future. Friends, I come to the end of my talk. I am greatly privileged to deliver the first annual memorial lecture. To me, it is a great privilege and honor, and I will not be, it's a bit of an emotional moment for me, and I can only say that I've had the opportunity of giving some lectures here and there, but I can say that throughout my life, this first annual memorial lecture will be one of my most memorable lectures which I have given. Finally, Justice Kalifullaa mentioned that he looks around, he can't see a single statesman. Sir, I don't subscribe to the gloom and doom theory. What I feel is, there is a famous saying that every great man like Sri R.Krishnamoorthy leaves behind a legacy. And what is the legacy he leaves? I have had the occasion of being his junior in two important matters, but I always try to observe very many seniors, try to learn from them. Each senior has got his own unique features, own special qualities which you can try to imbibe, try to learn from. As far as Shri R.K. sir was concerned, I must say honestly that he never raised his voice. He was an example that you can be firm and dignified. I have not seen him make a sarcastic remark against the other side, crack a cheap joke. His arguments were the embodiment of dignity and brevity. I've also never seen him argue for several days at length. So when you say that there is no statesman around, what Samuel Smiles said was, the legacy left by a man tells us that we, with the same effort and the same dedication, can reach the heights which people like RKs are also reached. And if you say that there are no future RKs around, I will say amongst the young students, maybe in the next 15 years, 20 years, we'll get some more RKs, some more Maslamanis, some more Kalifullas in the years to come. Thank you so much.